Hi, Catherine.
Hi, Oziana. Did you notice that we're on episode 21 today and it's the 21st?
Oh,
That's
wow. I just realized that. Yeah.
yeah.
Wow. Yeah. So our show today is what if businesses couldn't incorporate? What's that about, Catherine?
Well, we always take swipes at corporations because of all the unnecessary complications they've provided to us, but we've almost gotten used to it, and it's sort of people have a hard time imagining life without the possibility of being incorporated.
Right.
And
Right.
uh, the of course, during biblical times, there was no such thing as incorporation, and that I can tell, they didn't start really until the 1700s, to
Yeah.
some degree or other. And some of the first corporations were exploration ventures, um, and and then they were, and some of the ones that came after that were banksters. Those were the
Yeah.
first corporations. They didn't really catch on, and they really caught on big in the United States in the 1850s. But as far as what the Bible has to say about corporations, it isn't much, but they do sort of address the idea of falsity,
Uh-huh.
and and the notion that some people just seem to be just too big for themselves, and they had to have the titles,
Yeah.
and that's what I think they were addressing when it said at various places in the Bible, I think in Old and New Testaments, that God is no respecter of persons, and
Mm-hmm.
that seems to be the English translation, and that's the word that's selected in the Cabal statutes and codes. So
Yeah.
a person is a title. It's just, and we've said this before. It's like being like a role. Um, Being a person is being like a having the title of police officer, the title of CEO of a corporation, the title of citizens, the title of um, uh, any kind of role uh, that subjects you to the rules of um, other false entities, other corporate, groups of people
Yeah.
that like to rule over us. You're false, we're false, we can regulate you. Um, and One of the big attractions, of course, of being incorporated is unlimited, or I should say, limited liability. Now, let me get back to my notes so I don't skip over important stuff. And
Mm-hmm.
don't let me forget to put in the comments section that the link to the now 20-year-old
Corporation.
documentary called The Corporation.
I can actually put it in there now.
Okay, that'd be great.
Yeah.
Um, okay. Let me see. Still having trouble getting back to my notes. All right. So, Valentine's Law Dictionary, and this goes back, I think, to the 1800s, defines a corporation to be an artificial being, invisible, intangible, and existing only in contemplation of law. Well, that's close. It's a mental construct, and there's a case citation too. Um, they Okay, and then we got in small banking corporations existed in the first years after the American Revolution. They didn't really get going until the Boston Manufacturing Company in 1813. Okay. The big advantage seemed to be the limitation on liability because you could get investors that way. Normally, if I own a business, or if I'm one of two or three people who own a business and we operate that business in our own names and we harm people, maybe, okay, let's say A, B, and C. A, B, and C are all people, let's say, and they form a business, not a corporation. And they do business and they harm somebody, D. D gets harmed. And A might have been the one that harmed him, but A, B, and C are running their business together. So if D is injured by the actions of A, B and C could be liable too because they aided and abetted in the operation of the business and therefore the harm that was caused to D.
Yeah.
So now what attorneys will tell people is, oh, if you're B and C, you want to invest in that business that A is running, then you don't want to be liable. You want to be able to screw over D. You don't want to be liable. And of course, it's put in more delicate terms than that. But I'm just astounded at how many people fall for that, and they think, oh yeah, I want to incorporate. I want to sell ice cream on the corner. So during the summer, I want to be a corporation. Why? If you're a corporation, you've just gotten yourself tangled up with other corporations that are going to rule over you. And I'll give some examples later on. But if I want to become a really large ice cream purveyor and I want to get large contributors, it's hard to imagine. I suppose, I could harm people by selling ice cream. And certainly it's gotten to be such a knee-jerk reaction that large investors they just automatically will not want to invest unless it is a corporation. Everybody's afraid of a lawsuit.
That's
and
true.
So they don't want to potentially be liable. They're okay. I'll invest $10,000 and I'm okay with losing $10,000, but I don't want to risk losing $50,000.
Right.
Well, maybe you're going to have to keep a close eye on the business. Maybe businesses shouldn't get to be so large that you can't keep control over them. What an idea. That's what would happen if businesses could not incorporate. Because by incorporating, you're saying, I'm open to the possibility that I will harm other people, and I don't want to be responsible. That's never going to be a good deal. It's certainly not going to be a godly position to take. But that's what has happened, and it's not surprisingly turned around and bitten us in the butt. There are many people who have just, as a knee-jerk reaction, have incorporated. During what was called the Gilded Age, and that was, I think, toward the end of the 19th century, the age of the robber barons, the growth of railroads and oil and electricity, and the development of America's first giant national and international corporations. Forming a corporation was pretty simple and only required registration. And there were certificates of convenience and necessity because it was recognized then that this is not really a common law concept. I've seen other case law acting as if it was. I don't believe that being incorporated was ever a common law concept. Certainly not a godly concept. But corporations did begin to take off because size became important. If we want to have a railroad and we want it to go from one end of the country to another, that's going to take a lot of capital, and we need to raise a lot of capital if that's our goal. And I don't know why did we ever need that as a goal? But people thought they needed that as a goal. We got to connect one end of the country to the other. So we need to raise a lot of money fast, and we got to raise it from people who don't want to risk, people who are professional investors who don't want to risk anything. And make no mistake, people were injured and people were killed during the construction of the railroads by the robber barons. They weren't called robber barons for nothing. At that time, when government was not a corporation, they actually were concerned about being regulated by government. But of course, that's not a concern so much anymore.
What year did the government become incorporated again, Catherine? Do you know?
1871.
Oh, okay.
That's pretty. I mean, there might have been other signs of it before then, but I think basically that's when it happened. And they had the Lieber Code, and yeah. So, but other corporations were going strong in the middle of the 19th century, before the Civil War.
Right.
And the government would assist them, and some of them would, governments would give them gifts to encourage these corporations to locate here or there. There was always a good reason.
That's still happening.
Yeah, still happening. They'll hire people. It'll be good. It'll be good for the people.
Mm-hmm.
Right.
They get lots of perks.
And but at one time, even John Rockefeller and Andrew Carnegie didn't want to be subsidized because they knew that there was going to be some strings attached to that. Well, they don't have to worry about that stuff anymore. No strings, because the government itself is incorporated and is investing in those same corporations. So they're not going to want to make it difficult for the ones they're invested in to make a buck on the backs of the people. So they're not going to unduly regulate them. Do corporations always lead to monopoly? I think eventually they always do. And if only because they enable unlimited growth. Again, from investors who are looking for risk-free investments and no liability. Because if you can get really large, really fast, you can, as a business, you can outcompete the mom and pop version of your business. Because what you do is you engage in predatory pricing, and you undercut the competition, and you charge below cost, and you do it long enough that you can drive mom and pop out of business. And then when mom and pop and any other competition is safely out of the way, you jack your prices way up again, and you have an unlimited share of the market, and nobody can challenge you.
Wow.
And there are other businesses that, by their nature, lend themselves to corporations that are huge, like the railroads we talked about. because or electric companies or water companies, because maybe there's it's called barriers to entry. It takes a lot of money to even enter that market.
What is it called again?
A barrier to entry.
And what is that? What is that again?
There's certain kinds of businesses, by their nature, the barriers to entering those businesses are very high. It's hard. I mean, I can't just start an electric company tomorrow. I got to buy a bunch of this and a bunch of that and hire a bunch of people, and it's really complicated. Now, if I want to open an office supply store, it's not, the barriers to entry into that business are not very high. Okay. Not compared to running an electric company.
Yeah.
So it took longer to become a monopoly, for the government to become a monopoly. And there was a fellow, a Frenchman, a French philosopher, that said that the worst type of monopoly was a monopoly on education, because then you monopolize the way people think. But a case can be made that the bar monopoly is worse, because because bar members participate in and financially benefit from contracts, a series of contracts, commercial activity, that these activities are designed to deceive the people into a widespread but false belief that whatever is enacted by bar members and called statutes or codes is law. And that belief is pretty widespread and has been around for a long time. So that monopoly, or the appearance of a monopoly, and that's maybe all you ever have, is the appearance of a monopoly. If people were to get together, they could bust up that monopoly. But that requires some organization. The bar members also, have been very effective and this has been going on even since before the revolution with the European bar guilds. They drove it into the minds of the people that the only source of justice that people would ever have would be from the tribunals that the bar members were creating and running. And that they had to abide by the statutes and codes that the bar members enacted. At first, of course, in the United States, they had the idea that they recognized that enactments of bar members might not be such a great idea, and they enacted the original 13th Amendment to the first Articles of Confederation that prohibited bar members from serving in positions of public trust. They didn't name them as such, but they said those who had emoluments from foreign powers, and that's who they meant. That is definitely who they meant. This was back before the 1787 Constitution. This was during the period between 1781 and 1787. And there was a definite move on to physically destroy that 13th Amendment, not the 13th Amendment we see today, but the original 13th Amendment that prohibited anyone, and there's a few other provisions about not serving in positions of public trust if you have an emolument from a foreign power. And the title Esquire is an emolument from a foreign power. Okay, and then one of the other ways that bar members keep people believing in the monopoly power of the bar-run so-called justice system is is to make these contracts and statutes and codes in legal proceedings so difficult, so complex, that only bar members will be able to lead them through the complicated maze that they have made. So, now back at the turn of the last century, because of the robber barons, even, I'm surprised it didn't arise because of bar members. People weren't upset about bar members yet. Not enough to do this, but they were really upset with the Rockefellers and the Carnegies and the Mellons and those guys. And so they had enough political clout to enact the Sherman Antitrust Act, also known as 15 United States Code Chapter 1. And then the latest version of the other statute that goes with
the Sherman Antitrust Act, that is pertaining to monopolizing, yes. Right? Which is, right, of course, what the bar association does. 100%. Right. 100%.
Yeah. And it doesn't have to be an out and out monopoly. There can be what they call oligopolistic practices where, you and maybe, well, like what we have in the communication business.
Can you say that word again?
Oligopoly.
Okay.
It's like there's monarchy, one ruler, and oligarchy, where you have a group that rules with dictatorial powers. With monopoly, you have just one big corporation running everything. With oligopoly, you have two or three. And the two or three that have survived don't act like competitors to each other. They act like they're partners. And that's the same. So the effect on the people is basically the same as if they were a monopoly, even though the corporations have different names, different boards of directors, and so forth. And a lot of times they will, they'll buy each other out too. It's just easier that way. And since the Department of Justice, who used to be the ones that would bring, Sherman and Clayton antitrust prosecutions, hasn't been doing that to any degree since the 1970s. They've just been asleep at the switch. They harass a few businesses that are barely past the mom and pop stage. That's what they do. They don't attack the really miserable corporations that are oppressing people. With an oligopoly, like we have in the communication business, I remember being concerned, and a group of us in Ross County were concerned that it was down to maybe 7 or 8 corporations that were running and owning all the newspapers in America, all the they parceled it out. They shared this oligopolistic power. They would control, Disney was one, and I can't remember the names of some of the other ones. They owned radio stations. They owned television stations. You name it. They had control over everything. Now, there might have been, a mom and pop newspaper here and there that survived, and there still are. There still are. Not many, but there still are. And they that, along with the monopoly on public education, is very frightening because it gives the people one message, one source of information. And at least right now, with the relatively free internet, although of course we're seeing that's inroads are being made against that too. We have somewhat greater freedom, maybe than we've had before, to express different points of view. But it's something, this monopolistic or oligopolistic power is something that we have to constantly be on the watch for. And, as long as we've got like one source that's regulating it, which is pretty much the Federal Communications Commission, I'm not sure how protected we really are. At least, you and I have been able to get this broadcast up and running, but, we've experienced censorship. And anyway, incidentally, though, for those who do want to make, who want to use either of these statutes, the Clayton Act provides monetary compensation for persons who are injured. Of course, you have to be a person, so you have to be a corporation to benefit by the Clayton Act. The Clayton and Sherman Act, like all their statutes and codes, apply to legal fictions, not to corporations and legal fiction persons. But they do make it a felony to participate or to attempt to participate in monopolistic practices. You'll never see them prosecuted for that. I mean, I hate to say never, but very rarely, certainly not effectively. There's in case anybody thought that, there was an upside because of the limited liability, that there's an upside to being corporate, and that's something that, is a good idea for your family to be in. If you're going to be in business, you should be incorporated. But once you incorporate, you have just entered, the twilight zone of regulations designed and only applicable to corporations. You'd have been better off taking your chances as doing business in your own name, incurring your own liability, if any there is, in your own name. It sounds scary, but let's look at the alternatives. Let's say you incorporate. Well, one of the more famous cases where some people who were really upset about this was back in 2002, I think, when Hillary and I can't remember who was running it, but it was a group of Republicans, and they were upset, and they wanted to form this organization called Citizens United, which later became a famous case that went up to the U.S. Supreme Court. They didn't know at the time they formed that they were going to have all those attorney fees to pay, but some bar member probably told them, you can't just, what they wanted to do was they wanted to put out this film that was anti-Hillary Clinton. That's what they wanted to do. And they didn't like the film Fahrenheit 9/11 either. They wanted to go after that. But if they'd done that in their own names, who would have told them they couldn't do it? I would suggest to you, nobody could have told them that they couldn't do that. the First Amendment would have protected them and their and the law of the Creator, because the First Amendment does not apply to persons. If you'll notice, the First Amendment protects the free speech right of people. So they do know when to use the term people instead of persons.
Really?
Yes.
Huh. Interesting. Very interesting.
So Citizens United, they just somebody told them they had to be a 501c4 or C3 or whatever it was that they were. So they organized that way, and bingo, they were automatically subjected to the, what was it called? The Feingold, it was the Campaign something Act. Where is it? The McCain-Feingold Act, also known as the Bipartisan Campaign Reform Act, that prohibited any corporation, nonprofit organization, or trade union from posting certain types of electioneering material within X number of days prior to an election. Well, when the heck else are you going to post it? After the election? So if they had just stayed people, truly citizens, well, People United, maybe citizens, automatically the word subjects them to the corporate state. If they hadn't incorporated, they wouldn't have had to worry about the McCain-Feingold Act, but they didn't do it that way. And so they went to, I think, the trial court level with it, the intermediate appeal court level, and then they ended up in the United States Supreme Court with it. And how much do you think that set them back? Probably quite a bit. Finally, they got a 5-4 vote that the film could be shown, which they could have had anyway, before the 2008 Democratic primary election.
Yeah.
So now that's the case that people, you hear that they're upset that they call a corporation a person. Well, the only way that the people running Citizens United even got this eventual victory was because enough members of the court, 5-4, not that much of a majority, saw behind the corporate structure, and they will do that. They will pull back the corporate structure sometimes and say, after all, these are just people. This isn't like it's really a big corporation. And so they said, and so as people, they're entitled to First Amendment. But they also said, but they didn't leave it at that. They didn't say as people, we'll look behind the corporate structure and we'll just find that the people running Citizens United are entitled to First Amendment rights because First Amendment protected rights, because the First Amendment says so. No. We had to say, and what the Supreme Court said is that the Citizens United was a person, a legal fiction person as a corporation, and that the corporation had free speech rights under the Bipartisan Campaign Reform Act.
Wow. Yeah. You catch it all, don't you, Catherine? People don't catch this stuff, they don't get it. But so I'm glad that you're here explaining this, really.
They really always want to show us that we really need them and that they really have our best interests at heart. And that's why they're enacting all these statutes and codes that make our heads spin.
Yeah.
That's the common denominator, and I'd say more and more people are seeing that.
Right.
There was another matter that came about around the same time, with another small family, well, relatively small family business that had unfortunately incorporated Hobby Lobby stores. And a lot of y'all may remember that. And they probably could have run a perfectly fine business, family business, maybe without incorporating. Maybe they wouldn't have probably been as big, but for whatever reason, they incorporated. So that meant they were subject to the Religious Freedom Restoration Act. Okay. So, and that challenged their ability to, that what they were doing is they were refusing to pay for their employees contraceptive services as part of the health plan. I think that was maybe the birth control pill. They were opposed to that on religious grounds. And some entity in the corporate government took issue with that, or maybe, some of the employees did, and they wanted the employer to pay for their contraceptive services. Okay. And they were, by God, entitled to it. And they went to court over it, so-called court. And Hobby Lobby found that as a corporation, they had to jump through the hoops of the Religious Freedom Restoration Act. Sure didn't look like their religious freedom was being enforced very much, but eventually I guess it was. Many attorney fees later. I'm not sure. I think that was around the same time as Citizens United. Now, what has come to my attention recently as we look to enforcing our common law judgments against people who work for corporations, who have holdings in corporate financial institutions, whether they be banks or investment houses. We don't care what they call themselves because we're the people, and we don't recognize fictitious entities that don't really exist. Why should we? And why do we have to, since even they have admitted that we, the people, are the source of all law? And if we say that having an imaginary friend called corporation is not lawful, who's to tell us that we can't disregard that corporate structure? And so I believe that that's the position that we will be taking when we enforce, and everybody's always going on about, well, what about enforcement? What about enforcement of your common law judgments? Well, that's actually, I don't know how people enforce judgments and the fake judgments in the corporate system. That's way harder than this is going to be.
Yeah.
So that has caused me to butt into this other case that's more recent. This is from 2020 from the Seventh Circuit. That includes a number of states, corporate states, including Illinois. And that's the one that I sent you the link to. That's Halpern versus Richards. And that was where some people that were harmed, these third parties, we'll call them when we talk about a corporation and how it's allowed to harm other people, third parties, without liability, sometimes there is liability. And apparently the people, the third parties who were harmed in this case by the actions of a corporation, found themselves in.
Is this the right case that I have showing right now, Catherine?
I'm sure it is. I will. Let me switch screens.
Okay.
Yeah, that's the one. Mm-hmm.
Okay.
If y'all try and get through it, it's quite lengthy and convoluted, and I could hardly get through it myself. And I'm used to reading this stuff. But they were talking about,
Oh, this is recent.
yeah, 2020 Seventh Circuit.
2021, right?
They were talking about the people who operate these corporations, and including specifically the directors, the very people that we're going to be serving our notices of lien on, in our notice of execution of lien. So here's their dilemma that was spelled out in the Halpern versus Richards case, and the complicating factors in that case, all created by corporations. The company, the corporation, had directors, and their directors, the CEO and other people, were what was called dual hat directors. Sometimes they wore one hat, sometimes they wore another hat, while still operating as employees or agents of this corporation. One of the hats that they wore was the hat that the federal corporation imposed on them through ERISA, ERISA, Employees Retirement something, Insurance something something. And it tells corporations that they have to provide, or if they do provide for health care, they have to do certain things. They have
It's Employee Retirement Income Security Act.
Okay, thank you. So don't forget that the Federal Cabal Corporation imposes its own rules on corporations that it allows to be in business. And one of those rules is you have a fiduciary duty to your employees, not because they care about their employees, but because for other reasons. And a fiduciary duty is the highest duty of loyalty. You're running a corporation, so here you got two duties. As a director of a corporation, you have the duty to make as much money as possible for the corporation, right? You have another duty to make sure, under ERISA, to make sure that your employees have the best possible health care. Yeah, how's that going to work? You got two conflicting duties. And Halpern versus Richards is not the first case that has run into these dueling, conflicting duties. Well, in Halpern, then you got a third interest. What about the third parties that we're injuring too? Usually through our employees, the same ones that are being insured by ERISA, by our ERISA program. So who's our duty to? And that's what the decision is about. And I'm not really sure how they came down on it. They probably do what appeal courts like to do oftentimes, is send it back to the trial court and think about this more and think about that more. And how about this? We'll send it back to you. Try again. And if you don't do it right, we'll see this case again.
Yeah, make it last as long as you can. Bring us some more money in.
Yep. Well, only the attorneys are making money off of this. I guess, and it seems very plausible with the with ERISA, or even with protecting the rights of the people protecting the rights of the people that the corporation injures is considered maybe it's the lowest level duty that a corporation has, is to protect those rights. Remember, they've got limited liability. So they have a greater duty the people running the corporation have the primary duty to make money for the corporation. That's their job. It's not their job to make sure that people they injure get compensated. That's not their job. And that's why in Halpern versus Richards, they were in bankruptcy court because they wanted to extract themselves from this obligation. Now,
but isn't that why these corporations are insured? So wouldn't it be the job of the insurance company to compensate those that were injured? I mean, that's what they have insurance for, isn't it?
But these insurance companies weren't born yesterday, and they know what these corporations are up to, and so they've got these exclusionary clauses. These
the small print.
Yeah, but they exclude coverage for certain types of events. And, I think we're all familiar with, we can't, like if you're a homeowner and you have an insurance policy and you look later, there's a huge storm and your roof blows off and you want your insurance company to take care of it. Well, the insurance company says, well, you've got an act of God exception. And the storm that blew off your roof was an act of God. We can't insure against that.
Wow.
And yeah. And that's not the only kind of exclusion that they have. There was a time that we, those of us who are objecting to children being turned over to abusers, we were actually trying to network with. I remember a meeting we had in Austin, Texas, and there was an insurance rep there. And at that time, I guess they hadn't figured out how to write their homeowners policies in such a way that if children were being raped in the home, that those children, when they got to be old enough to sue, would not be able to sue and get compensation from the homeowners policy. Wow. They had not really encountered that before, so it had not occurred to them to exclude that. So they were sort of working with us at the time because we had the same interests. We both wanted to, punish the child rapists. And certainly, I don't know. I don't think that went anywhere. But just because you have insurance doesn't necessarily mean that you're going to get coverage. And there's if there's a dispute, and these insurance contracts are sometimes a little vague and misleading, and a corporation usually can protect its own interests pretty well, but an insurance corporation can protect its interests too. So you find that they're entering into insurance contracts that have some ambiguous terms in them. And what does ambiguity lead to? Litigation. And the people who are advising on both sides, that's not a problem for them, right?
Yeah.
But it is for the ones who want the insurance coverage. The ones who want to only collect the insurance premiums without paying out claims, they have the opposite problem. So anyway, but when you come into a dispute with your own insurance company, whether you're a corporation doing it or whether you're a homeowner doing it, it's called a bad faith claim. I did one of those once, and I represented a man that was had a fire, and then a number of years went past, and he had another fire, and claimed against his insurance, and they're like, no, we think it was arson, and they kept using the previous fire. I can't remember the details now, but the jury got to hear it all. They weren't going to buy two fires. So.
Right. Wow.
So so he didn't get coverage. So back to Halpern versus Richards, with this business that apparently harmed a third party and tried to bankrupt out of it. They also had duties to their employees, and some of those employees might have actually caused the damage, the harm to the third party. So you can imagine how complicated that got. And then, you've got all these conflicting loyalties, these conflicting duties, one of which, they call it in the lawsuit, they call it the common law duty of a director to the corporation to make a profit. I don't think the common law recognized corporations, much less that there was a common law duty of a director of such an entity to protect profits. I don't believe that, but that's the way the so-called court, the Seventh Circuit, read the thing. That there was that duty, there was the duty to the employees under their health policy, and then there was the duty to the the duty to the third party. I guess they got a judgment, so that imposed the duty to the third party, the injured party.
Yeah.
And they couldn't reconcile all three duties at the same time. They had originally enacted whatever the legislation was, ERISA, and there was some other stuff, because what was happening is these corporations, some of the directors would see that the corporation was going insolvent, and they would take steps to artificially increase the value of the shares of stock, and to benefit themselves, in other words. So whenever you got large corporations, you've got the people who operate those corporations and others seeing large amounts of money and assets that they can plunder, and they can take advantage of the confusion created by all these conflicting duties to plunder the corporation. And it's turned into a mess. It's turned into a mess because of greed. And I mean, what other motive could there be for the formation of these corporations?
Yeah. Catherine, there's some comments on some live comments on the YouTube.
Okay, yeah,
I don't know if you wanted to respond.
Yeah, let me see. I see your comments. I don't see.
Oh no, I mean on the YouTube, on the live YouTube chat.
Oh, okay. I need to go to the different screen, don't I? If I can find it. One of the comments is, your heraldry is your evidence of nobility and the privilege to God's promise that our names are entitled to, hence birthrights, which are inalienable and intrinsic. Your given name and family name are your titles to your birthright, to personal real property, freedom to speak and choose. Okay. I'm not sure I'm understanding that. To the extent you're talking about exemption from tax and utility bills, as sovereigns, we are not required to pay tax anyway. When you claim exemption's a privilege, not a right. Once you start claiming exemptions, you're saying, yeah, you can rule over me, but I'm exempt. I'm a special case. I don't know what my heraldry is. Evidence of nobility and privilege to God's promises that our names are titled. I'm just not understanding the word usage.
Yeah.
The rule against perpetuity.
The definition of heraldry says the system by which coats of arms and other armorial bearings are devised, described, and regulated. We'll have to look more into that. Right, Catherine? Yeah.
Yeah, I'm familiar with the rule against perpetuities. Is that what you're talking about? That's kind of a really archaic concept that as to when property can be conveyed. I don't know what heraldry is. Rules against okay.
I just wanted to bring that up.
Anyway, but we haven't answered the question, and maybe we should do that and then start to wrap this up. What if businesses could not incorporate?
Right.
Well, they probably wouldn't be as large as corporations have gotten to be by a long shot. They wouldn't be able to trade on Wall Street.
Right.
Because when you trade on Wall Street, you're dividing up ownership so that part of the ownership is, and you bundle up the ownership of some of the assets with your ownership of other assets, and you chop them up. And I don't know, I can't follow it, but you're eliminating the liability part of the asset when you trade on Wall Street. And I'm not so sure that there's not blowback from that. If you're operating a mom and pop business, you're keeping it simple and you're dealing probably with business within your own geographical area, maybe a 4 or 5 county range, depending on how big your family is and how many people you can get to work your business. But if you stay out of the corporate world, you may actually have business assets that you're going to be able to pass on to your sons and daughters if they're intelligent enough to operate your business and not plunder it. And that's what we used to have, is the intergenerational transfer of wealth. When you start incorporating, though, and you start subjecting yourself and your businesses and your assets and your family and your physical cells to corporate crime syndicates, you're not going to have that, because they're seeing theft as the way that that's their business model, is theft and violence. So, yep. I don't think it's going to be, people think that the sky would fall if we didn't incorporate, but I don't see it that way.
Yeah.
Let's see if anybody, if Grant wants to comment on that, or Keith wants to comment on that. Anybody thinks that would be a bad thing? I'll tell you, I have been incorporated. I have done business as a corporation, as an LLC, and I never saw any upside to it. And I do business on my own name now, and or the name of a couple of us, I should say.
Uh-huh.
And
I posted the link for the documentary of the corporation, the full
oh,
documentary.
awesome.
But I did it before and it just disappeared. So we'll see if it sticks.
Well, you could try and post it again, maybe. I don't know.
Well, it's on there now. We'll see if it lasts.
Okay. Okay. If not, we'll post it tomorrow. Okay. Well, if anybody, we're talking about the possibility that we may only do every other Thursday. And, you know, both Luciana and I do have a lot on our plate, and we
Quite a
have
lot.
basically no help. So we are looking to, we're always looking to grow the court, the Ohio Circuit Court of Record, and we're all happy to, we're both happy to, I have a lot more available time, I think, than Luciana does. Feel free to contact me at WLJAradio@AOL.com if you're interested in our broadcast, you're interested in being a member of our court, you know, if you're an Ohioan, or if you're in another state and you want to form your own common law court with others. I'd be happy to walk you through it, talk to you on the phone, go through your documents line by line, and help you through that. There's another common law court in the original Texas Republic that has recently started, and they do things similarly to what we do, but not exactly the same. And remember, every state was originally and still is considered a sovereign republic. And that means government by consent. So if you don't consent to what's going on in your state, you might want to get started with putting together the pieces of a government by consent. And I think the key to that is having a place where people can go for justice. And anyway, so without using the corporate format to do so. Okay, is there anything else you wanted to bring up, Luciana?
No, I did put up your personal email address, and Catherine is very responsive. Sometimes I send you emails, you know, just to look over something because I don't have time to look it over, and you always respond, and you stay very busy, but you're very much appreciated for all the time that you spend on this.
Thank
you.
You.
Very
you do so much stuff, Luciana, that it just would be beyond my abilities. So I can't thank you enough. So apparently comments are being erased
already. Yeah.
Already.
Oh, that was fast.
Yeah. That's another thing that we have talked about because of the YouTube censorship issue. We may be going to another platform.
That is very strange.
But that's going to take some more time and effort to do.
Yeah.
All right, everybody. Well, we appreciate those of you who are listening tonight, and will be listening when this gets put out there tomorrow. And
yeah, we always take the broadcast from the night, and then the next day, usually the next day, it's still on the live side, but we also put it on the regular video side too.
Okay. Thank you, everybody. We'll talk to you next time.
Thank you,
Hope
Catherine.
to hear from you.
And God bless you all.
God bless you all. Good night.
Good night.